We are in the state of Massachusetts for that all-important evidentiary hearing for Aidan Kearney, who goes by Turtle Boy. He's the blogger charged with witness intimidation and conspiracy back in October 2023, all in connection to the murder case of Karen Read. Let's head back into court now. The judge has just taken the bench.
Court is in session. You may be seated.
Good morning, Your Honor. May I call the case?
Yes.
For the record, before the court, numbers 1 and 2 on today's is Commonwealth versus Aidan Kearney, 23 CR 313, 24 CR 43. Mr. Kearney is present, along with his attorneys Timothy Bradel and Mark Betterow. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for hearing on various motions. If the parties could please identify themselves for the record.
Good morning, Your Honor. Robert Cosgrove for the Commonwealth.
Good morning, Your Honor. Timothy Bradel on behalf of Aidan Kearney.
Good morning, Mark Betterow from Mr. Kearney.
Okay, good morning. First things first, I served with Attorney Cosgrove when he was Judge Cosgrove on this court, and I think this was the only place we overlapped when we were sitting at the same time. I don't think it raises an issue for me, searching my own conscience. I understand that fact has been disclosed to defense counsel, and defense counsel doesn't have an issue, but I want to just flag that and make sure that's correct.
That's correct, Your Honor. We're fine with it.
And does the DA's office have any problem with my presiding?
No, Your Honor.
All right, so that out of the way, tell me what you think we have on the agenda for today. We had it scheduled for an evidentiary hearing on suppression. I was hard-pressed reading the papers that I could find a reason for an evidentiary hearing.
You're right, Your Honor. And in light of the recent series of concessions or admissions or stipulations, if you will, of the Commonwealth, we're not proceeding with an evidentiary hearing. We're going to be proceeding with documents from the acknowledged record of the case on the unreasonable delay issue, emails, quotations from the record. I just have exhibits that I would be offering as I argue.
Okay. Not entirely clear to me that I have seen everything. I had a lot of stuff was coming in fast and furious over the weekend, and so I'm not sure I've seen everything. But we'll take it as it comes.
Sure.
Let me just ask, in terms of the history of the case, is there now an order for the prosecution of a taint team's review of any kind of electronic data?
No, that's an issue that, I'm sorry, Mr. Bradel.
No, go right ahead.
That's an issue that I would hope to raise today. There's a motion before the court presented by Mr. Bradel to essentially abort that process and return the seized items to the defendant on the grounds that the Commonwealth has unreasonably delayed in following through on the taint team process. So
I just thought I saw something in one of the papers that I reviewed, that the issue of a taint team and the procedure that it would follow was submitted to another judge and was considered by, I think, her. I think it was Judge Rayburn. And I don't know if I think it was even referenced that she took it under advisement, and I didn't want to step on her toes if she had something under advisement in regard to that.
That was my understanding as well, Your Honor, that she took that motion under advisement at the end of the last hearing. That was the last I have heard of it, frankly, and I don't know if she has, in effect, ruled by silence by simply scheduling the hearing on Mr. Bradel's motion to dismiss for unreasonable delay first today, and not acting on the taint team motion, or whether she is still contemplating filing something. I don't know if the clerk has any insight on Judge Rayburn's plans.
Am I contacting Judge Rayburn to find out if she feels like she still has anything under advisement, or if it's still open to this court to reconsider anything or consider anything that she hasn't decided.
None on the Commonwealth's part, although I would ask the court to advise her that in light of some of the filings today, the Commonwealth has filed a superseding suggestion for the taint team process. So much of what she now has, I would say, is probably obsolete.
Judge, my take on it, I have a pretty good memory of this part of it, is that that on that date, counsel had proffered a motion providing a framework for a taint team. I came in that day and announced to Judge Rayburn that we intended to file a motion to suppress for unreasonable delay, and that I suggested that that should take precedence over ruling on the taint team framework, and she agreed with that. And so I don't think she's I don't think we're going to get a ruling. I don't think she has anything under advisement. I think she agreed with me that she was going to hold off on that in light of what we're about to do here today, which is the unreasonable delay motion.
Mr. Bradel may well be correct. I would just say that our recollections differ.
Just as a matter of courtesy, it would be in my inclination to call her and make sure that she doesn't feel like she has anything under advisement. Do you have any objection to that?
No, not at all.
So I'll make that call when I get off.
Thank you.
All right, now, is there a logical order to take up the matters that are
I was going to suggest, Judge, the motion to suppress, and then my brother's going to argue the Rule 17, Rule 14 issues, and then I'll take up any other residual issues we need to talk
Okay,
about.
why don't we deal with the motion to suppress? Any objection to that, member?
No, I think that's fine, Your Honor. I have a couple of things I've filed that I would want to address at the conclusion of the defense motions.
Sure.
So, as I said, this is going to be a motion where it's on the documentary record. I have exhibits that I've given to counsel that I'm going to proffer to the court as I go, if I may. And we're going to be relying on basically the documents I'm going to be proffering to the court as exhibits. The docket, if here and there I may refer to dates that are in the docket. For example, there's a May discovery deadline that came and went. I'll refer to that. And then stipulations of counsel, where recently in this last group of filings from the Commonwealth, they stipulated and agreed that Mr. Carney's phones were searched,
Right.
which was kept from us till that acknowledgement. So that's a whole other issue that we want to get into. But I would use that as part
Doesn't
of
seem like it was kept for you because at least Mr. Federer's letter references it, so you had
Yes.
information about it. Maybe it wasn't disclosed in the Rule 14 process, but it was known to you. But in any event,
Yes,
why don't
it's
you
known to
just,
us.
I don't need to wind up.
Sure.
Get at
Okay.
it.
Sure. Absolutely, Your Honor. So, Your Honor, in this case, I came into this case on 10/19, Your Honor, and I immediately sent an email to Special ADA Mella saying that basically, hold on a second here, these phones have all sorts of privileged materials in them. And so I didn't have an exact clear picture of what was in them at that point, but I knew from
There was
time.
no assertion of attorney-client privilege.
Yes, and other privileges too, Your Honor. This is
There was no assertion of attorney-client privilege in October, right?
Initially, I said there was privileged material, knowing that there was source material, journalist source material. The most important thing that I was concerned about right when I came into the case, Your Honor.
All right, we're going to hit the pause button right there. You're not going to miss anything. Straight ahead, more coverage out of Dedham, Massachusetts, and this important hearing for Aidan Carney, better known as Turtle Boy, and his motion to get his cell phone back. Stick with us. We'll be right back.
Convicted murderer Sarah Boone faces sentencing after leaving her boyfriend to suffocate inside of a suitcase.
He's in the suitcase still. There are multiple domestic violence incidents.
You two hitting each other.
Sarah. That's my name. Don't wear it up.
He told you, Sarah, I can't breathe.
George Torres locked inside of a suitcase, begging for help.
I thought he was okay.
The Suitcase Murder Sentencing. Live coverage today on Court TV.
And welcome back to Court TV Live. I'm Matt Johnson. Thanks for being with us. Let's head back now to the Commonwealth of Massachusetts for an important hearing in the case against Aidan Carney. The blogger, also known as Turtle Boy, was charged with witness intimidation and conspiracy back in October 2023. Those charges in connection to the murder case against Karen Reed. She's accused of killing her Boston police officer boyfriend and claims it was all part of a massive police cover-up, her charges. Well, let's head back into court now for his hearing, where his attorney is arguing the return of his confiscated cell phone.
Which was that these phones had source material given to Mr. Carney from confidential sources, some of which were law enforcement people, about the very same investigators that had seized the phones. So that was the primary concern right at the beginning.
Preventive medicine doesn't deal with that, right?
It doesn't.
Preventive medicine deals with the attorney-client privilege.
Yes, but there's other...
In your initial disclosures or your initial representations, you were not representing that there was attorney-client privilege material on the phones.
Right, not on the first day or two when I got the case. I didn't know that yet. But I did say, hold on, there's privileged materials in these phones. And I wasn't certain exactly everything that it was. And my first concern was these source materials. And there is a protocol in the court. I'll give the court the citation. I don't have it right off the top of my head here. It's in my papers, but I'll give you the citation that a court needs to do a preliminary determination when there's journalist source materials raised. And I properly raised it. And I said that you know...
This was prior or it was before or after the issuance of the search warrant?
It was after the issuance of the search warrant.
After issuance of the search warrant. So a judge had previously authorized the seizure and search of the phones, right?
It's a little more complicated than that.
One thing I didn't have is the search warrant affidavit, search warrant and the affidavit in my review of the papers. Maybe it's in here somewhere in some previous filing, but it wasn't attached to any of the papers that I saw.
Okay.
So I need to get that.
All right. Couple of dates. 10/6 is when Judge O'Shea issued the warrants. 10/11 was when they were executed, and 10/13 was the dates they were searched and extracted. And we didn't know that specifically until counsel gave us the Celebrate reports, which showed that Trooper Garino searched the phones on 10/13, and I have those, and I'm going to proffer those up as an exhibit. And Judge, the first exhibit I'd offer is my first email to ADA Miller.
And right. Do you have a pile of these exhibits? Just
I do, sure.
Give me the 10 exhibits that you want to introduce.
Sure. Here you go.
Okay, you got 10 exhibits. How many exhibits you got?
Thank you. It depends how you want to do them. If you want to do...
Are these in order?
Somewhat, Your Honor. There's emails, then there's statements.
Right. So let me just see if there's any objection from prosecution to any of these.
None, Your Honor.
Okay. So just for the record, we have an email from Tim Brado, subject Carney, date October 19 at 3:57 p.m. We have Commonwealth representations regarding searching phones, a single-page document. We have applications.
All right, watching along with you at home, here to discuss is law enforcement expert Sonny Slaughter, a friend of the program. Sonny, thanks for being with us on this Monday. Okay, so when we're talking about the return of these cell phones, confiscated after his arrest, this took place in October of last year. So the Commonwealth has had them for more than 13 months. There's a bit of a discrepancy here between the Commonwealth and defense team saying that this phone was already looked at and downloaded. But what's interesting about all of this is there's a special team that looks at the device before it's supposed to be downloaded so that there's no privilege violated.
Absolutely. Good morning, Matt. Thanks. Good to be with you. So whenever there's an investigative case, there's a special team that has nothing to do with the case, has nothing to do with the investigation, and they're also not allowed to talk to the investigators or the attorneys or anything. They look at the information to ensure there's no privilege regarding the defendant and their attorneys. That means they take out and they say what can be looked at, what cannot be looked at, and ensure the integrity of the case going forward. These individuals have nothing at all to do with it. So that would have happened. And the fact that they have these phones since last year is actually not that uncommon because it is evidence in a case. But that happens in every criminal case that you can find. It happens at the state, federal levels, that this information is sequestered, if you want to say, that can't be seen or reviewed by anyone else.
All right, Sunny, we have about 30 seconds left. What are you watching for in this hearing? You're going to be sticking with us next hour.
I'm looking to see what the judge says is admissible and not admissible in this case. It's a very unusual case for somebody to get tangled up in a legal proceedings based on something that on another case. It's unusual. So I'm looking for everything.
Yeah, and you know, on the docket, this was billed as an evidentiary hearing, but then the attorney says, I'm not going to even be arguing that. I just want the return of these items. Sunny Slaughter sticking with us. We're approaching the top of the hour. Still ahead, we head back to Massachusetts for more in this important hearing of Aidan Carney, also known as Turtle Boy. You're watching Court TV, your front row seat to justice. And welcome back to Court TV Live. I'm Matt Johnson. Happy to be with you for this hour, filling in for Julie Grant. This hour, we are tracking a few major cases here at Court TV, coast to coast. Suitcase killer murder trial. Sarah Boone's sentencing begins at 1:30 Eastern. That's in Florida. Also, we are in the Commonwealth of Massachusetts for Aidan Carney's hearing. We'll get you back into that courtroom in just a moment. And in South Carolina, jury selection is expected to begin in the deadly wedding night trial for defendant Jamie Kamarowski. All right, let's head back to Boston area now, where defendant Aidan Carney, the blogger known as Turtle Boy, that hearing is underway. Let's get you back into court.
Page document which has certain highlights on it. We have a screen share or what do you call this?
A screenshot.
Screenshot. Thank you. Which in the middle says Windows cannot open the folder.
That may not be. That may not have to come up, Your Honor.
I'm sorry.
That may not come up, Your Honor. It's a.
All right. Then we have a progress report of an extraction from Trooper Guarino. We have two of them actually.
Those are 1013, Your Honor.
Then we have a copy of. Looks like the same email from Tim Bradel. You don't want a duplicate copy.
I don't need a duplicate, right?
That's a duplicate. And then we have a email from Brian Tully to Tim Bradel dated April 27, 2024, which is a multi-page document.
Actually, Your Honor, the stapled copy is a series of emails going through December 20th. This refers to my request for a taint team and to cease searching, and it lays out the factual back and forth about the Commonwealth's refusal to
This is
cooperate.
April 27th?
I have, it's a packet that begins with October 19th, and the last page is a December 20th email.
I see, okay.
Do you have that?
Yes.
Okay. So that lays out the initial.
We'll mark these in the order I just identified them.
Sure.
Okay, and one. Looks like 1 through 7.
Thank you. So, Your Honor, at the very beginning of this case, 1019, as soon as I was retained on this case, I asked if they would agree to the appointment of a taint team on 1019. I cited the preventive medicine case in that email. Counsel, if you ask me, clearly didn't apprehend, Counsel Mello clearly didn't apprehend anything about the case law about a taint team. He, on the same day, he said he would not agree to any third-party review. That's the second email. And he said he doesn't know how far they've gotten. And we were going to go to Stoughton Court at the time. I was going to go in there with a protective order to stop any searching and ask for the taint team in light of their refusal to cooperate, even though I cited the case. And a couple quick things about preventive medicine, Your Honor, I know you're aware of it, is it puts an affirmative duty on the Commonwealth to go to Superior Court and put before the Superior Court a protocol to protect any privileged documents. And
which privilege?
Well, that's the question, Judge.
Preventive medicine deals with attorney-client privilege.
Preventive medicine deals with attorney-client privilege. There's other privileges as well. Like I said, I'll give you the case. I just don't have it right in front of me. The case law says that when there's journalist issues, the Superior Court will do a review, a preliminary review of it.
And nice to have that.
I'll get it to you. It's in my computer, Judge. I'll get that to you. But just for purposes of my argument right now, I'll just say that was on the table as well. He's a journalist. He has all this source material.
All of that was known to the judge who issued the warrant authorizing the search of his records, right?
I don't know, Your Honor. I don't know. I suppose so. You know, these things are, you know, it's the Onyx White language, Your Honor. The cell phone is
what?
The Onyx White case, Judge.
Onyx White.
There's some language out of that applies here, and the language is that you know, a cell phone is you know, the file cabinet of everyone's entire life, and it's akin to you know, issuing a search warrant for an entire city as opposed to one residence. There needs to be a focus on the overbreadth of the warrants here, Judge.
Well, that's a different motion.
Well, I don't think it's a different motion. I think it's another privilege that I wanted to bring before the court. And so that's what I was doing at the time, was saying, hold on a second, we need to deal with this tainting issue. And at some point, it was communicated to me.
Said no.
At some point, it was, yes, he said no on the 19th.
Okay, and then you filed a motion for protective order or something?
I filed it in Stoughton District Court, Your Honor.
And what happened on that?
And then Attorney Mello came in and said, well, we're indicting the case anyway, so, and it wasn't heard in Stoughton District Court.
So you renewed the protective order in the Superior Court post-indictment?
So in Superior Court, Your Honor, at that point, you know, the chronology is important. In November, Your Honor, that's when Attorney Mello did an about-face and said, okay, we're going to stop searching. And Attorney Mello made all sorts of vague, contradictory statements about what the status of the phones was. And those statements are in one of my proposals.
So there's no contest that was abided by, the Commonwealth abided by that representation. That is to say, there was no searching after Mello said we're going to stop searching. The searching that you're talking about that obviously happened back in the October time.
October 13th, Your Honor.
Right?
Correct.
Before you even asked for the tainting.
Right. We had no idea that happened.
Okay.
And it was never disclosed to us. In fact, it was covered up, and we were lied to about it. Okay. And one of my exhibits, Judge, is 6 quotes from the Commonwealth. And just so I'm clear here, Judge, we have no beef with Attorney Cosgrove's veracity on anything. We're talking about, you know, he was brought into this thing later, and we're not saying that he participated in any cover-ups or misrepresentations. But the first 4 are all blatant lies. If you look at number 1, this is the document marked Commonwealth representations regarding searching phones. That exhibit, Your Honor, indicates number 1 at 11/28/23. Mr. Mello said, the state police and the investigators have not perused the material. It is in pristine form, located on the defendant's devices. That is a complete falsehood, and we know it's a falsehood because on 10th...
I'll go back and listen to the hearing and take it in context. Okay?
Sure, go right ahead.
I'll look at it.
All of these are all misrepresentations, okay. So they've misled us as to the state of the evidence. And they not only had the search of 2 of my clients' phones...
How are you prejudiced by that?
How are we prejudiced?
It's obviously there was a search. The search happened.
Yep.
You're gonna get the contents of the search, right? The extraction. Where's the prejudice?
The prejudice, Judge. So first of all, this is a suppression for unreasonable delay. My brother's going to talk about discovery issues and prejudice, but in terms of an unreasonable delay, Your Honor, this all goes to the reasonableness of the delay. But to answer your question, I know you always want to answer a judge's question when they ask you a question, and the answer is, the prejudice is that the whole reason the Commonwealth was doing this was to stop Mr. Carney's reporting. That's why they didn't want to give him back anything. They wanted to get in there. Remember, at the time, the FBI was investigating these people. They were dying to know what was in Mr. Carney's phone about the FBI investigation of these people. Mr. Carney was eating their lunch in the media, exposing them for all sorts of untoward behavior in the Karen Reed case, and they wanted to stop this reporting. They took his phones under this never-before generated theory of witness intimidation. They took all of his devices, they cleaned out his house of every computer, iPad device in there, and they kept it. And it was full of his source material.
You're looking for a sanction in a criminal case that would advantage your client, unrelated to what you are described as the prejudice. The prejudice is different, the inability to report. And if he was somehow hindered in his ability to report, I would have thought that you would have petitioned for the return of the phones. Why the phones are so important, I'm not sure I know. Is there an affidavit to that effect before me?
We did petition for that, Your Honor. We asked for the phones.
When was that? Where's the motion? Where will I find a motion for return of phones?
We asked for the...
Is there a motion for the return of the phones?
I don't think we got that far, Your Honor, because we were under the...
Okay, so now the next question. Is there an affidavit describing the prejudice that you described?
Judge, the prejudice is that a journalist has had the tools of his trade taken from him, and every single day he cannot access the tools of his trade. That's the prejudice.
If somebody takes my phone, I go to the Apple store the next day, buy a new phone, and I'm up and running. Right? There's no problem with that.
No. He couldn't do that, Your Honor.
So that's why I'm asking for an affidavit. Okay? And I don't have an affidavit from you, right?
Judge, you know, we have provided so much to the Commonwealth, asking for the phones back. We were under the impression they were not searched yet. You know, you got to remember that we were under the impression they were not searched yet. So we wanted either a mirror image of the devices or the devices back, because that's what the Commonwealth does in these cases, is they have the ability to give the phones back. There's no issue with the fact that the Commonwealth can take a mirror image of a device and then return the devices. In the series of emails, Attorney Mello said, no, we're not returning the devices, we're not giving anything back. And Judge, and also in terms of the items in the phone, Judge, it's not just the journalistic tools of his trade, it's that we needed to use the phones to defend Mr. Carney against these allegations. They're looking for evidence of these supposed instances of witness intimidation. We need to look at them and push back and look at the phones to defend Mr. Carney. I mean, it's not just the journalism issue. It's that this is evidence that we still, to this day, 11 and a half months later, we still don't have. We still don't have it. So this motion that I'm before the court on is focused on unreasonable delay. Right. Not prejudice, unreasonable delay. And so, but there is prejudice, and I think I answered you that we can't defend Mr. Carney, he can't do his job, and these people are the targets of Mr. Carney's. This goes to the conflict of interest that's been throughout this case all along, Your Honor, is that these are the very investigators that are supposed victims in these 16 indictments in the 23 case, and yet they're still the investigators on the case. And they're targets of Mr. Carney's reporting. Mr. Carney's reporting is in his devices, and they go steal his devices. This thing stinks, Your Honor. So Mello delays the first month into late November of a year ago, Your Honor, saying no tainting.
Let me just focus you on the law for a second.
Sure.
Okay.
All right, in case you're wondering, this is being held in the smaller courtroom there that doesn't seat the couple hundred that's next door, but just a couple dozen. And in the gallery, you may have noticed, it appears that his girlfriend is there, along with several of the supporters wearing those T-shirts that he sells on his website. All right, still ahead, more of the defense arguments for the return of defendant Aidan Carney's cell phone of his pre-trial hearing. We'll be right back.
Coming soon to Court TV.
It's the biggest story that we're covering.
He is the boogeyman.
Lori Daybell.
She said, I will have you destroyed.
She's got another murder trial coming up.
A social media sensation, now a suspected killer.
We will not stop fighting. We have no quit.
Sean Diddy Combs arrested on a federal indictment.
The high-stakes trials you don't want to miss. Coming soon. Only on Court TV.
Welcome back to Court TV Live. We are in Dedham, Massachusetts this morning for an important hearing for defendant Aidan Carney, a blogger also known as Turtle Boy. Carney is accused of numerous felony counts of witness intimidation and conspiracy related to the murder case against Karen Read. He's accused of intimidating those witnesses in her case. Let's get you back into court now, where the defense is arguing over the return of cell phones.
The counsel submitted an opposition that describes at length that the cases that you recite and rely on are not cases where a warrant was authorized for the seizure of the device and search of the device. And here we have that situation. Are you referring me to any cases that deal with the timeliness of the search when authorized by a prior warrant?
I anticipated you would be concerned about that issue, Your Honor. Here's my answer. There are no cases, no appellate cases in Massachusetts. I couldn't find a case across the country where a investigative team had a warrant and then sat on it, didn't disclose anything to the defense for over a year, and was suppressed for unreasonable delay. There's no case where an investigative team did that. I think that's probably a good thing. This is an anomaly that, in this case, the investigative team got a search warrant, searched 2 of the devices, lied about it, kept it from us for almost a year, and then sat on it and didn't share any of the stuff with us, and pretended that they didn't search the devices to us until 9 months ago.
Is there a trial date in this case?
No, Your Honor.
Usually delayed disclosure is assessed against the prejudice to one party or another. And here we don't even have a trial date yet. So obviously this stuff is going to be disclosed ASAP, right? Whatever was imaged and extracted from phones in October is going to be disclosed ASAP.
Well, I appreciate that.
We're going to talk about a schedule for that.
Sure, I appreciate that, Your Honor, but that's too little too late as far as we're concerned.
And obviously, if there's going to be a search of the other devices, there's going to need to be a taint team at least to evaluate your argument that there is attorney-client privilege material on the phone, on the devices, right? That's going to have to be resolved, and that's going to have to be done on an expedited basis.
Yes, Your Honor.
But I am hard-pressed to understand the basis for your suppression motion.
Judge, let me talk about the unreasonable delay. It's cited in my brother's memorandum, and it's the bedrock principle is that reasonableness is the touchstone of every search. Reasonableness. Unreasonable delay, the case law talks about, all the cases talk about when a phone is seized without a warrant, but the delay in getting the warrant. And that delay is never there's some outlier cases where it's a few months that they allow. But the most of the case law, and it's all cited in my brief, is that it's 2 weeks, 3 weeks, a month. That's it to get the warrant and get the search to go.
Right, without a judicial approval.
Yes.
Grabbing something that belongs to somebody else, seizing it,
right,
and hanging on to it for investigative purposes, you need a judge to say that's okay. And essentially that's what happened.
Yes.
Right? The judge said it's okay to seize these devices from Mr. Carney.
Yes. But where reasonableness is the touchstone of every search, reasonableness still applies. And reasonableness doesn't allow the Commonwealth, in this case or any other case, to sit on evidence and deprive us of evidence for over a year. How much they searched it, they've obfuscated it all over the place. At the time, we were under the impression nothing was searched. And then Attorney Bettero's letter of 1017, Your Honor, that you referred to, that's around the time when we first realized, not from the Commonwealth, from a whistleblower from the Stoughton court who supplied us with an extraction dated 1013. That's how we learned that the devices were searched. Up until that point, even Mr. Cosgrove was in the dark about that these were searched. Mello lied about it. He knew about it 100% because he authorized, according to Tully's testimony, he authorized the extraction to go to the Stoughton court back in October of 23. So there's no question that Mello knew about this. Still didn't disclose it and misrepresented to the court that these phones were not searched. So we were misled as to the fact that they were searched. If we knew they were searched...
I think I understand your argument. I should hear from Mr. Cosgrove on the issue of motion to suppress, and then I'll hear on the 1417 motion.
My last point, Judge, if I may, is that reasonableness doesn't go away. And the fact that they got a warrant and then did nothing for a year, that has to implicate reasonableness, Your Honor. And it is, if you use the warrantless cases as a yardstick, this amount of time, Your Honor, is insanely beyond the pale and was done for an ulterior motive of violating Mr. Carney's civil rights and depriving him of the ability to start defending himself. Thank you, Your Honor.
Your Honor, for the record, Exhibits 1 through 7 have been marked.
Thank you.
I will be brief, Your Honor, and confine my remarks to just a couple of comments. I don't take from Your Honor's questions to my brother that you necessarily have made any decision about my arguments, but I do take from your questions that you've read my memorandum and understand the essential points that the Commonwealth has sought to make, chief of which is that at least 6 days before Mr. Bradel came into the case, and before he made any request in terms of setting up a taint team, and even then made no mention of attorney-client privilege, the phone had already been searched. It had been downloaded. Lieutenant Tully had looked at it. Attorney Mello has not looked at the extraction report. I have not looked at the extraction report. But certainly in terms of purposes of the law of search and seizure, once the phone extraction is made and once the report was perused, certainly by the time the report was perused by Lieutenant Tully, it had been legally completely searched. So from my point of view, whatever the reasoning was back at the time, whether Attorney Mello didn't quite understand the significance of the Cellbrite report or for whatever reason, I don't understand, frankly, why there would be any purpose at that point to have a taint team after the cat was out of the bag with respect to those items. There certainly would be a purpose at whatever point Attorney Bradel represented to Attorney Mello that there was privileged attorney-client privilege material. In stopping any further search, we still had, I think it's 4 additional cell phones, the exact number escapes me, that were found in Mr. Kearney's closet, and we still had a laptop computer and some other paraphernalia that had not been searched. Mr. Mello's initial representation to Mr. Kearney that the Commonwealth would cease further search, I think, was precisely accurate. I think some of his later statements are fairly susceptible to interpretation. He seemed to go back and forth between saying, we'll cease further search, or the devices have not been searched. And even that statement is true if you're talking about all of the remaining devices other than the 2 cell phones that were searched. I emphasize that there has been no harm to the defendant. He has plenty of time to examine the Cellbrite reports. I have yet to look at them, and I represented in my memorandum that I would not do so until he had a chance to bring the issue before this court. But I have here on a thumb drive both of the Cellbrite reports, and there's no need to set a deadline for the Commonwealth to turn that over, Your Honor, because I'm going to hand it to Mr. Bedro right now, and I'm pretty confident that he will share those with Mr. Bradel, and they can go through those reports to their heart's content. And if there's any privileged material, whether it's a reporter privilege or attorney-client privilege, although as noted, Lieutenant Tully did not find any.
All right, here to discuss, we have our expert for this hour, law enforcement expert, Sonny Slaughter. Sonny, that was kind of dramatic there in court. Here is the information. I'm going to hand it over to counsel. They have it right now. I mean, I haven't seen that before, but aside from that, it turns out that they actually did download the phones as soon as they got them before consulting this special team.
Exactly. So when I heard that, my ears perked up and I said, oh, Lord, here we go. You know, Massachusetts seems to have this problem with process, Matt. You are the expert on the ground. You've been there. But the narrative from the community and what is happening in the criminal justice system has really tainted, for lack of a better word, the entire process for all of the cases attached to the Karen Read case trial. And this is problematic because if they looked, gleaned, reviewed, or did anything that could have been privileged, that takes the whole case, because that is not how the process is supposed to work. The tank team needs to be first, the process, get the warrant, get the material, have the tank team already in place, let them review, and then you can look at anything other than that complicates and is not out, and it doesn't follow the process. It is out of order. And when things are out of order, you have chaos, which is what we are seeing right now. And I just don't think that Massachusetts is doing a really good job at showing us what the criminal justice system should be or could be. It's showing us all of the things that it should not be.
Well, you know, right before all of this with Karen Read's case, before we even got to Turtle Boy's case, we had the Sarah Birch case and the distrust in law enforcement already. So this was bubbling and brewing in this very small town, tight-knit community north of Boston, to your point. But these attorneys were also arguing the fact that they wanted specific information outlined in the warrant that investigators could collect from these devices. 5, it sounds like. 5 cell phones and 1 laptop. Is that how it really works, though? Do they say, we're only going to look for this, this, and this? Or is it just a download of all the material? Because you never know what you're going to get.
So they try not to get too specific in the search warrant when you're looking at that. Just like you said, you don't know what you can get from there. So it would generally be, we're going to access this information now. They can't go in and get stuff that they should not have been looking at, or like this information that should have went to the filter team or the tank team. But it's usually not that confined in the search warrants that I have looked at as a consultant, that I have gone over with law enforcement, because you don't know what you will find. And if you get too broken down in the minutia of everything, then you might see something and then have to go back and get another search warrant. But as you said, in the other case prior to the Karen Read case, the Birch case, this just seems to be a long brewing conspiracy of, well, not conspiracy, but problematic. That I'll just say it's just all problematic.
Well, yeah, you know, I mean, this is the reason why we're here, right? Like, there are people that are very divided in this community there.